Who is empowered to punish the advocates for misconduct? To understand who is empowered to punish the advocates for misconduct, we must look at the Advocates Act, 1961, which governs the legal profession in India. This act creates a structured system to regulate the conduct, discipline, and ethical behavior of advocates. The key answer to who is empowered to punish the advocates for misconduct lies in the powers given to state bar councils and the Bar Council of India, BCI. The primary authority who is empowered to punish the advocates for misconduct is the State Bar Council's Disciplinary Committee. Every state bar council has a disciplinary committee empowered to hear complaints against advocates. When any person, client, or court files a complaint of professional misconduct, the State Bar Council examines it and, if required, refers it to its disciplinary committee. Thus, the first level who is empowered to punish the advocates for misconduct is the State Bar Council. However, the Bar Council of India also plays a central role in determining who is empowered to punish the advocates for misconduct. The BCI acts as the appellate authority over decisions made by state bar councils. If a party is dissatisfied with the decision of a state bar council's disciplinary committee, they can appeal to the BCI disciplinary committee. Therefore, the BCI is also who is empowered to punish the advocates for misconduct at the national level. Another important point is that the Supreme Court and High Courts have inherent powers, but they are not the primary bodies who are empowered to punish the advocates for misconduct under the Advocates Act, 1961. Courts may take contempt action, but not disciplinary action under the Act. They may, however, refer misconduct cases to the Bar Council. This means courts influence the system, but they are not the statutory bodies who are empowered to punish the advocates for misconduct directly under the disciplinary framework. Under the Act, misconduct can include breach of professional ethics, misappropriation of client funds, dishonesty or fraudulent behavior, violating Bar Council rules, bringing disrepute to the profession. To address such wrongs, the Act prescribes clear penalties. These penalties are imposed by the competent bodies who are empowered to punish the advocates for misconduct, which include reprimand, suspension from practice, removal of name from the roll of advocates. These actions can only be taken by the disciplinary committees of state bar councils or the BCI, which confirms again who is empowered to punish the advocates for misconduct under the law. The process works as follows. 1. A complaint is filed. 2. The State Bar Council reviews it. 3. If prima facie evidence exists, it is referred to the disciplinary committee. 4. The committee hears evidence, examines documents, and allows the advocate to defend himself. 5. It delivers its judgment and imposes punishment if warranted. 6. Appeals go to the BCI, and in some cases, further appeal to the Supreme Court. This structure clearly shows who is empowered to punish the advocates for misconduct, ensuring that the legal profession maintains integrity, dignity, and fairness. Another reason the bar councils are who are empowered to punish the advocates for misconduct is because they are self-regulatory bodies, meaning the legal profession governs itself. This ensures impartiality and insulates disciplinary processes from governmental interference. This independence strengthens the legal system and preserves professional ethics. Furthermore, empowering bar councils as the authorities who are empowered to punish the advocates for misconduct ensures that disciplinary action is based on specialized understanding of legal ethics, advocacy standards, and courtroom behavior. Since bar councils consist of lawyers, they understand professional norms more deeply than external bodies could. In summary, the authorities who are empowered to punish the advocates for misconduct are state bar councils, through their disciplinary committees, Bar Council of India, as the appellate disciplinary authority. Courts may take contempt action and refer cases, but they are not the statutory bodies who are empowered to punish the advocates for misconduct under the Advocates Act, 1961. Thus, the legal profession is regulated through a structured, independent disciplinary system, ensuring ethical behavior and accountability.